Great. Good morning, everyone. So I'm Danny Bradlow. I'm a professor. I'm the SARChI Professor of International Development Law and African Economic Relations in the Center for Human Rights. And it's my pleasure to invite you, to welcome you rather, to this panel on reimagining business and human rights in the times of COVID-19. We have a great panel to speak to you today of people who all connected with the center in different programs, many in the International Development Law Unit, which I run, but in the center as well. The topic is as you'll see from the various presentations, is that the crisis, even though it's primarily a health crisis and secondarily, I suppose, an economic crisis, is also raising important questions, not just about human rights and the right of access to people to be tested for healthcare, for livelihoods, etc., but it's also raising questions about what are the responsibilities of business. How should they respond and how should they conduct themselves in regard to this crisis and their activities in this crisis? And we've got 4 presentations that look at this issue from in different ways, but all fit together very nicely and raise the question as a whole as to what's the function of business in this difficult time. Before I introduce the speakers, just a couple of housekeeping announcements. One is, can I ask everyone to keep their sound on mute, just so we don't get any disturbance and everyone can hear the speakers as clearly as possible. Secondly, I'm going to remind the speakers that they should each speak for about 10 or 12 minutes. So we have lots of time at the end for questions. Because the presentations fit together so nicely, we're going to go from one presentation to the other, and then we'll have questions at the end. As many of you probably know, there's a chat function which you can find at the bottom of your screens. Please feel free to enter a question there or a comment there at any time, and I'll collect them, and then we can come back to the questions at the end. What I'll do at the end is, I don't know, depending on how many questions there are, I'll invite people to either present the questions themselves, or if we under pressure of time, maybe I'll just say a few questions just so that we can get as many questions as possible answered and get as many people to participate in some way in this session as possible. So without more, let me introduce the 4 speakers in the order that they're going to speak. The first speaker is Dr. Benjamin Traoré, who is the project manager in the Secretariat for ACCA, the African Coalition for Corporate Accountability, and is a postdoctoral research fellow in IDLU as well. He's going to speak on, and the title of his talk is, "Every Cloud Has a Silver Lining. Is COVID-19 a Catalyst for Business and Human Rights?" So talking about the big picture of business and human rights. He's going to be followed by Dr. Jonathan Kabré, who's a postdoctoral fellow in the IDLU unit, and is going to be talking about host states' regulatory powers in times of COVID-19, challenges and opportunities. So how does the whole issue of the rights of a host state to regulate foreign investors for social policy purposes, and how does that affect potential disputes between host states and their investors? The third speaker is Luis Felipe Yanes from the University of Essex, who's also a visiting researcher in IDLU at the moment, but is a doctoral student at the University of Essex, stranded in Pretoria at the moment, but I think happily so for the moment at least. And he's going to talk on, let me just find the title. His talk is "Do No Harm During COVID-19. Rethinking the Positive Obligations of Private Healthcare Providers." So what's the obligation of businesses that provide healthcare in this difficult situation? And then the last speaker is Genny and Ngende in the Secretariat for ACCA, who is going to be talking on reconciling the business of vaccines and human rights of test subjects. So the really important question with companies that are developing vaccines and want to test them on human beings, what are their responsibilities and obligations in that regard. So I think they fit together really nicely and will raise the issue of business and human rights in a very thought-provoking way. So let's begin with Dr. Benjamin Traoré, who I know has a PowerPoint presentation which he'll put up on the screen, the share screen now. And Benjamin, you've got 10 minutes from now.
Thank you very much, Professor Bradlow. Good morning, everyone. I'm Benjamin Traoré. So even if this event has been organized by IDLU in collaboration with ACCA, I just want to say from the beginning that the view that I'm going to express here are not necessarily those of ACCA. So my task today is to set the foundation, and as Danny has mentioned it, to show the big picture. And with regard to the time limit, I will be going a bit quickly and fast. So my hope is that we will have time for more discussions after. So yes, I think you can see can you see the screen?
Yes, Benjamin, you can see it.
Okay, so I will just start by some introductory remarks on business and human rights agenda in general. And my presentation will focus on three main points. I would just want to talk about the need that COVID-19 has revealed as the need for an urgent rethinking of economic globalization. That would be my first point. The second point, I will focus on specific obligations that is generally accepted as an obligation on companies, which is the due diligence obligation, human rights due diligence obligation. I will talk very briefly after about the labor conditions and workers' rights in times of COVID-19, and I will finish with some concluding remarks. So very quickly, what's the whole business and human rights agenda about? I want here to give you a kind of overview. So for many decades, human rights violations have been usually associated with conduct of states, as most of you know. Since the end of the Cold War, however, the consolidation of globalization and the new political situation has increased, and political and economic situation has increased concern around businesses' activities and how these activities actually can have very perverse impact on human rights. So various initiatives have been put in place to tackle this issue, and particularly at the international level. This has led, as most of you know, to the adoption of the so-called UN guiding principles on business and human rights. So the guiding principles include, very importantly, in addition to obligations that are bear by state, in these guiding principles also include the responsibility for businesses to respect human rights, in particular the obligation that I was talking about before, the due diligence obligation. So, but this agenda, this I would say the guiding principles have actually critical flaws. So first of all, the guiding principles are not legally binding. So that explained why there is actually an ongoing process for the adoption of another international legally binding instrument. This process has started in 2014, so after the adoption of the guiding principles. That shows us that the guiding principles have some flaws that might be, must be actually filled. And most importantly, the guiding principles actually don't provide for direct human rights duties on businesses. And many states has also been reluctant to domesticate them, and especially to domesticate the due diligence principle. Many state and international corporations actually prefer voluntary measures and have therefore shown little interest or support to the process. This, as a result, has led to what we can call a kind of accountability gap in the field. So that's very quickly an overview on the business and human rights agenda. Now I'm turning to the first point of my presentation, the need for rethinking the global economy in light of what the COVID-19 has shown us actually. So the current pandemic has revealed the extreme fragility of the global economy and its business at any cost model. So liberalization, austerity measures, including massive privatizations, have weakened vital public services and fundamental economic and social rights. So COVID-19 has clearly shows us how this can challenge our societies and can show how little resilient we can be in this situation. So the model is environmentally unsustainable. It has led to global warming, and studies has suggested that zoonotic diseases such as COVID-19 are linked to deforestation, climate change, and biodiversity loss. So that's now turning to the third point of my presentation, giving the time limit I have to speed. The due diligence principle for companies. So the due diligence principle is at the core of the UNGPs, so the UN guiding principles on business and human rights. What's the meaning of this principle? Due diligence means that businesses have a duty to conduct human rights due diligence. They must identify, prevent, mitigate, and remedy the negative human rights impact that they identify in the course of their operations and throughout their supply and value chains. So COVID-19 actually and its economic effect have increased the risk of negative impact of corporate decision on the human rights of workers and communities. So some example of the violation actually of this due diligence principle include companies operating during the COVID time without proper protective equipment, refusal to reduce workforce in factories, and all these as a result increase the risk of infections. due diligence for businesses imply in this context, the duty to provide for appropriate working conditions in order to mitigate the risk of contracting the virus, and even taking proactive steps in limiting the spread of the virus. So an interesting example of this, the due diligence principle can be found in the need of providing for clean water. So as all of you know, we have been asked to systematically wash our hands as a preventive measure for COVID-19. So the due diligence principle here would be, for example, for employers to provide for clean water in order for the employees to be able to meet these basic requirements. So another important point that COVID-19 actually has revealed us is the need also to look at the labor conditions and workers' rights. So labor standards are one of the important subjects in business and human rights agenda. So the COVID-19 has have a devastating impact on millions of workers, especially those in the supply value chains. So just yesterday, for example, in Ghana, it has been reported that more than 500 employees were actually contracted the virus in a factory in the northern part of the country. This shows us how vulnerable or exposed can be workers actually in the times we are living in. So millions of value chain workers have been let out also without a social safety net, not to mention the health and safety issues related to the working during the pandemic. So this highlights the responsibility to respect human and labor rights in business supply chains in accordance with generally ILO regulations, but a specific one here, the ILO 2016 resolution on decent work in global supply chain. So I would like to just take this opportunity to speak about a very interesting case that has been ruled out just a few days ago by the South African Court of Labor. So it was about an application that sought to ensure protection for mine workers and affected communities in the context of COVID-19. So the Labor Court of South Africa approached the issue in a way that's in accordance, in line with the due diligence principle. This principle, which is obligatory, mandatory on states for sure, and also on businesses, to my opinion. According to the court, so some of the rulings of the court are actually very interesting and worth a close attention. So according to the court, the vulnerability of mine workers in turn renders the communities in which they live vulnerable to COVID-19. In other words, the COVID-19 pandemic presents both a public health concern and an occupational health concern. It is a risk for the entire nation, but it presents particular risk and requires particular responses in workplaces generally, and in mines in particular. So in the face of the global pandemic, according to the court, the spread of COVID-19 virus on South Africa's mines has profound implication for the country, neighboring countries, and especially for mine workers and mining affected communities. So this is a decision that was rendered just a few days ago. So I will just conclude now by some very quick remarks regarding the whole situation that are challenging some of the main aspects of business and human rights actually. What we can see is that some companies are actually taking the opportunity or the occasion of this situation to make excuses and not to comply with basic human rights and environmental obligations. So some states have been also complicit to this kind of behavior. Let's just think about the relaxation measures that the US has announced some weeks ago, and that impacts actually, or that aim to relax the human rights and environmental obligation for companies, specifically the regulations on pollution and so on. This is so we can consider that this is a kind of bad news, but also we have some kind of good news, I might say. Awareness has been also raised around this, in this context, around business and human rights issues. And I want here to mention the resolution that has been taken by the European Parliament, affirming that corporate human rights and environmental due diligence are necessary conditions in order to prevent and mitigate future crises and ensure sustainable value chain. And last but not least, the African Commission on Human and People Rights, in its resolution 434, this resolution is on the need to develop norms on state obligation to regulate private actors involved in the provision of social services. So I think there is a working group on social, economic, and cultural rights that has undertaken to work further on this resolution and to come up with concrete measures that can also be added to what already exists in that field. So I think this is a good note. And since we are still living in COVID time, we will see how all these things developed. But my hope is that we can, and the business and human rights community and all the stakeholders can realize that this is a very good moment to strengthen the business and human rights agenda. So that would be my last word. I hope I was not exceeding too much my time limits. I give back the floor to Professor Danny. Thank you very much.
Thank you very much, Benjamin. You were about a minute and a half over the time limit, but that's okay. But thank you very much for giving a very good overview of the topic, and also for ending on a positive note, because in this time it's not always easy to end on a positive note. So it's good to see you do that. But in the interest of time, I'm going to pass over to Jonathan Kabré for his presentation. So Jonathan, the floor is yours.
Okay, thank you, Danny, and thank you everyone for your attendance. So thank you also to Benjamin for this insightful presentation. What I would propose to do is to go straight to some of the challenges that African states may face coming from businesses in general and foreign investors in particular. as a response to the measures taken by those countries to fight the COVID-19, and also some of the justification that those states may give. And I will try to conclude with some suggestions. So what I can say is that what we are currently witnessing is an extraordinary situation. And such a situation calls for extraordinary measures. And this is actually what almost all the countries across the globe are taking now, with the closures of borders, with the lockdown, with closure of schools. And those measures are meant to curb the spread of this virus. However, those measures come also with a cost, a very important economic cost. And as the United Nations Conference on Trade and Development said a few days ago, it is expected that those measures that the flows on foreign direct investment will drop by 30%. And this is a huge and important loss. And it's likely that businesses in general and foreign investors in particular will seek relief and compensation for those losses. And the best channel for this compensation is to bring cases before investment arbitration. So the first idea is to say that most of those measures can be potential claims for ISDS, Investor State Dispute Settlement. Actually, a country like Peru has always been warned that some of the measures taken at domestic level can potentially give rise to some claims. And also, if we go back 10 years ago, when Egypt was hit by what has been called at that time the Arab Spring, with the riots, with the social movement, the protest, this country took some measures in order to maintain, to ensure its survival. This is what actually the government said before some tribunals. However, we can see that since 2011, the starting of the Arab Spring, at least 22 cases have been filed against Egypt before the International Center for the Settlement of Investment Disputes. And currently, this is the most, among all the African countries, Egypt is the first one in terms of cases. And if it is likely that some claims will arise out of this crisis, what can be the justification, the defense that our state can give, given the fact that this is a very extraordinary situation? For this, we have to look at the international law, and under international law, those justifications can be found either under the customary law or also in the international investment agreement. Under the customary international law, the International Law Commission, on its article on the state responsibility, gives us some justification, like the self-defense, the countermeasures. But in the context of the COVID-19, I think that 3 of those defenses are of particular importance. It is the state of necessity, the distress, and the force majeure. And what is interesting is that the state of necessity has been invoked by Egypt in most of the cases related to the Arab Spring. And if you want to take one case like the Union Phenosa case against the Republic of Egypt, in this case, this investor was saying that the measures taken by this state as a response to the Arab Spring finally led to the shutdown of its business. It is a Spanish company. But for the state, those measures were justified by the situation. And this state said that, maybe I will quote this, and it's an interesting statement, that it was the only way to maintain Egypt's security, public order, and stability, to safeguard its essential interests and maintain its basic services in the face of a grave and imminent peril. However, such a defense, the state of necessity, will be rejected by the tribunal because among the criteria for this defense, there is that the measures taken by the state have to be the only way to deal with the issue. And in this specific case, the tribunal found that those measures were not the only way to deal with the issue. And if I want to draw a comparison with what we're currently seeing, it's not likely that measures taken by some of our African states are the only way to deal with the issue. And this is evidenced by the fact that those measures vary from one country to another. And if I want also to have a look to the justification that can be found on the international investment agreement, mostly in bilateral investment agreement treaties, we have to say that African countries for the old generation of our bilateral investment treaties, they were not really balanced. This means that it's, even if we had at that time some provision safeguarding the power to regulate to state, it was not well drafted, and this led to some of vague interpretation by arbitrators. But this is changing with some of the recent investment agreements, like for example the Pan-African Investment Code, which preserve this power to regulate and even mention the public health exception. However, sometimes it's difficult for a state to successfully play this one. The measures need also to be bona fide, in good faith, non-discriminatory, and comply with the proportionality. And this is not really the case with some of the measures across the continent. And the combination of those unsatisfactory defenses has led some organizations, some institutions to call for a suspension of all the claims related to COVID-19 measures, because this will probably lead to unprecedented claims. And some organizations like the International Institute for the Sustainable Development, with many interventions in ISDS for the interests of African local communities, are calling for this. But I think that what we need to do is to seize this opportunity, because for me, in my view, in all the crises, there are some opportunities. And here, it's maybe also the time for African countries to come with a very ambitious agreement in this regard. We saw that with the Pan-African Investment Code, finally the mountain gave birth to a mouse, because what was expected and the final result is not what we were expecting. So maybe to come with a very ambitious agreement, since the negotiation for the Continental Free Trade Agreement Protocol investment will probably take place further in this year, to really safeguard this power to regulate of states, and also to ensure that in those kind of situations, states are not distracted by the potential claims that businesses, that foreign investor can bring, but that they're focused on the protection of their domestic interest. And I will try to close with a small metaphor, saying that currently the storm of the COVID-19 is raging, and while the pessimists complain about the wind and the optimists expect it to change, I think African countries should adopt a realistic approach by adjusting the sails. because there is always an opportunity in each crisis. Thank you.
Thank you very much, Jonathan, and thank you for keeping to the time, almost exactly at 10 minutes. And thank you for making some very interesting points for discussion on foreign investment and some things Africa can do to respond to that. Let me move now to Louise to talk about healthcare. Louise, the floor is yours.
Great, thank you, Danny. So I'm going to probably say a lot of things very condensed. So my apologies, because depending on your own level of expertise, both in international human rights law or in business and human rights law or international investment law, you might get more or less of what I'll try to say, but I'll try to be as comprehensive as possible with this kind of mix of the perspective which I'm about to say. So what I'm going to talk about is a paper that is going to be published in the beginning of July. So if there is a lot of questions unanswered, you'll probably try to respond some of them in the written work, and I'll be published in a month or so. And it looks about rethinking how we understand the obligations of private health providers, particularly during this crisis. But there are a lot of nexuses, as Benjamin was saying, which actually makes us think of what exactly, or how should we interpret businesses' obligations in the future outside of the pandemic. And you know, as Jonathan was saying, extraordinary times require extraordinary measures. There are, as you'll see, some parallels of, in particular contexts or particular countries, if those extraordinary times are not the normal times. And what I'm trying to say here specifically is it depends on the level of the public health system in each country. What we've seen in the last few months is kind of three different approaches to how countries have dealt with businesses that are involved in the provision of health service from a private perspective. The most kind of dramatically opposed has been the one in the UK and the one in Spain. So the one in the UK, which I've called a collaborative approach, is one in which the government called private health providers to support the country in providing medical services to those affected by COVID-19. And that approach was by compensating daily the use of such facilities. So it's a collaboration and immediate compensation. And this is quite dramatically opposed to the Spanish approach, which was a kind of set of nationalization in which the government took hold of all private health facilities in the service of the public. And that has implications to what Jonathan has been saying of possible future investment law disputes. And that's to be seen how investment law tribunals will interpret those disputes, given the specific measures that were implemented. Now, our current understanding of the obligations that companies might have, as many of you might know, is limited to the idea that businesses have an obligation to respect human rights. So in the typical set of the triage of obligations of states, which is to respect, protect, and fulfill human rights, it has been, in the last 10 years, understood that the businesses are only limited to respect human rights. It's also been called, in different words, as I use in the title, an obligation to do no harm. So it implies a negative obligation to not act in a way in which it implies affecting human rights. And if you do, then you have an obligation to provide certain type of reparation, which
Louise, we can't hear you. Taruna, is there anyone who can help unmute or unfreeze, I guess, Louise? Louise, can you hear us? Ah. Louise?
Or maybe
Maybe what we should do,
Genny.
switch to Genny, yeah. Genny, do you want to start, and then hopefully we can get Louise back in and he can pick up again.
Oh, sure, no problem.
So Genny, why don't you take up?
Of course. Yes.
And if he comes on, I'll tell him, I'll send him a message to wait.
Okay, I understand. Yes, so good morning, everyone, or good day, depending on where you are in the world. I would like to start my presentation with what I initially believed would be my concluding remarks. The abstract I submitted for this webinar stated that I would conclude by arguing that conversations around the testing of a COVID-19 vaccine should have a business and human rights perspective. This insinuates that from the onset that it does not. Upon further review, I realized that the reason we speak of accountability of non-state actors, like corporate entities, is because the human experiments and clinical trials conducted during the Second World War that subsequently led to the Nuremberg trials birthed this legal field known as business and human rights. Therefore, the testing of vaccines post-World War II is already a business and human rights concern. From the trials is the Nuremberg Code, which is a set of research ethics principles for human experimentation. There are 10 codes which ultimately speak on the elements that have to be present for there to be voluntary consent. For instance, there has to be an aspect of voluntarism, information disclosure, decision-making capacity, which ultimately leads to informed consent. Although the Nuremberg Code is not a legal instrument, the idea of informed consent has been universally accepted in international law. For instance, Article 7 of the International Covenant on Civil and Political Rights stipulates that no one shall be subjected to torture or to cruel, inhumane, or degrading treatment or punishment. In particular, no one shall be subjected without his free or her consent to medical or scientific experimentation. Article 12 of the International Covenant on Economic, Social, and Cultural Rights calls on states to prevent, treat, and control epidemic, endemic, occupational, and other diseases to achieve the full realization of the highest attainable standard of physical and mental health. This in turn requires the promotion of medical research and health education and fostering recognition of factors favoring positive health results. Similarly, the Convention on the Rights of the Child requires state parties to ensure that the views of the child are given due weight in all matters affecting the child, and that parents and guardians act in the best interest of the child. When it comes to vulnerable groups, as research participants, the Convention on the Elimination of All Forms of Discrimination against Women calls on state parties to establish legal protection of the rights of women and ensure the effective protection of women against any act of discrimination. This is further qualified by the Committee on the Elimination of Discrimination against Women, which stipulates that women have the right to be fully informed by properly trained personnel of their options in agreeing to treatment or research, including likely benefits and potential adverse effects of proposed procedures and available alternatives. Additionally, the Convention on the Rights of Persons with Disabilities recognizes that states must provide them with equal recognition of legal capacity and protection against non-consensual experimentation. And lastly, in the field of humanitarian law, the Geneva Convention prohibits biological experiments on wounded or sick members of armed forces. So this international legal aspect that has to do with informed consent also also has a presence in regional law, specifically the African system. The African Charter on Human and People's Rights recognizes that human beings are inviolable. Every human being shall be entitled to respect for his life and integrity of his person. In 1996, the Organization of African Unity adopted a resolution of bioethics in which it pledged to promote within the consent the obligation to obtain the free and enlightened consent of anyone to submit himself or herself to biomedical research. Vulnerable populations that may become research subjects are also afforded a special protection in Africa. For instance, the protocol to the African Charter on Human and People's Rights on the rights of women in Africa, as well as which is referred to as the Maputo Protocol as well, recognizes the right to dignity of every woman, and particularly relevant to the context of human subject research, prohibits all medical or research experiments on women without their informed consent. With regards to children, the African Charter on Human Rights on the rights and welfare of the child protects children's right to survival and development, their right to health, their right to protection against abuse and torture. In dealing with COVID-19 pandemic, the African Commission issued press statements calling upon states to adopt a rights-based approach that is inclusive and proportionate. The African Commission has continuously reminded states of their obligation to develop and implement a regulatory framework that addresses human rights violations by non-state actors. The Pretoria Principles have echoed the sentiment that states must hold business enterprises accountable for human rights breaches. Now, the international law provisions, as well as that of regional law, have been domesticated in many African national legal systems. The 2020 edition of the International Compilation of Human Research Standards shows that 26 out of 54 African countries have laws addressing medical research. Conceptually, it would appear that legal walls have been built preventing any breach of these rules. However, empirically, the legal walls will crumble when pushed hard enough. Over the last few weeks, there have been articles and talks on how most official clinical trials are not conducted in Africa, and should be because of the COVID-19 pandemic. However, what these experts fail to say is that not all clinical trials are made official and thus subject to public consumption. What should alert us are the ones that are unofficial and not subject to public scrutiny. A great deal of medical research on the continent is funded by US-based organizations or pharmaceutical companies. It is only those financially backed by federal government that are obliged to adhere to US laws when conducting clinical trials abroad. So this means that, for instance, the pharmaceutical companies are not legally obliged to follow anti-corruption and anti-bribery legislations like the US foreign practices. Now, coming back to this, the current reality, global economics and finance have been heavily hit by this pandemic, and Africa is no exception. Various African countries have obtained foreign aid and loans to help kickstart their economies. Every loan has conditions. There is a temptation to link the condition of the loan to clinical trials without stringent legal obligations. The provisions of foreign loans is very much an international relations field that can potentially result in adverse human rights implications, which is a legal field. So I conclude with this. Just as the latter part of the 20th century focused on mainstreaming human rights, irrespective of the field, we need to mainstream business and human rights. A focus on human rights only has the effect of ignoring the astronomical impact of businesses. Because to be honest with you, socioeconomic rights, like the right to health, have become commodities. And if we do not regulate this, we run the risk of informed consent being bought by the highest bidder. Thank you.
Thank you, Genny. You ended on a really nice provocative note, which hopefully will stimulate some questions. And thank you for keeping to the time so well. I just want to check, Louise, are you there?
I'm here. I
Great.
think the EduRAM stopped working here in Future Africa, so I don't know what happened.
Ah, Okay. I don't know exactly where we lost you, but I'll leave it to you to pick up where you think you need to.
Okay. I think I was talking about the nature of companies' human rights obligations, particularly the discussion around Ruggie's critique. I think I left it around there. So basically, when the principles were made, Ruggie said that in one of his reports to the late now Human Rights Commission, the UN Human Rights Commission, he said that companies couldn't have an obligation to fulfill human rights or any positive obligations towards human rights because it wasn't in their nature to do so. And some of the critiques, mainly by David Bilchitz, very strongly, and I believe very well, has been that he seems to have narrowed the idea of the nature of human rights, of the nature of companies, to only understanding them as profit-making institutions. And one of the things we have to explore is what are the specific actual nature of companies, particularly those who provide certain essential human rights services, such as health. And so when you actually review some of the mission or vision of private health providers, you'll read very beautifully done provide compassionate care and exceptional service to every patient every day. And so the centrality of the actual service in terms of health as part of the human rights is more related to the actual nature of a private health provider than the idea that they're just profit-making institutions. So what does this mean when you interpret the obligation to do no harm? My argument is that we need to re-understand the way do no harm or the negative implication of such obligation is, which is actually that when you're a private health provider operating in a country, specifically now during COVID-19, in which overall the public health system has lost its capacity or is in such a level of crisis that it has lost its capacity to provide medical services, then you're looking at an obligation that the actual negative implication has also a positive dimension, which is do no harm means that if you have the financial, material, and human resources to provide health services to those who are in need when the public system is overrun, then your obligation also implies to do so. So actually denying health services to those seeking it, if the public system is overrun, also implies a positive dimension to the negative obligation. This has to be contrasted in what I call a profit versus bankruptcy element, which is there's a difference for those companies, or so particularly those private health providers, in which such or providing such services would imply complete bankruptcy. And this we can see the situation currently occurring in Lebanon, in which the government owes private hospitals more than 1.3 billion. And a big difference in private health providers, for example, like United Health Group, in which only last year had a total amount of profit of $14.2 billion. So the two underlying questions at the end, which are not explored mostly in the paper, but which is one of the things we need to rethink, is the ethical dimension of profiting on health services and profiting particularly in situations of crisis. So some might be very willing to say it's completely reasonable, it's completely ethical. Many people or many businesses are actually made of profiting from crisis situations. And it brings a big debate in terms of business and human rights, of how do we understand ethical dimensions to the way we've constructed human rights obligations. And so at the end, I think the main argument is that this provides us, as Benjamin was saying, an opportunity to really rethink the way we've understood and actually try to and attempt to challenge some of the obligations that we currently understand, or the way we currently understand them. And this particular crisis, I think, demands us to look at some of the positive aspects of what a duty to do no harm means, specifically for those companies, which businesses is to provide services that are directly related to human rights. Thank you.
Thank you, Louise, and thanks for bearing through the being cut out. So we've had 4 really interesting presentations. One, and I think collectively what they really do is they put on the table, do we need to rethink business and human rights and what that means in a much newer, much more challenging environment? What lessons can we learn from the way it's been applied in, for example, in the Arab Spring, or some of the lessons drawn from that? How's it applicable to this situation? Genny raised the question of, have social and economic rights been commodified, which I think is an interesting question to look at also. The question of rethinking do no harm from Louise's presentation. And the question of what does due diligence mean, that Benjamin brought up. We have about 6 people in the list so far who want to talk, who have questions. I think we'll take them in groups of 3 to make sure we get them in. If you have questions, can you indicate them in the chat function, and then I'll keep a list and we can start. The first questioner was Palesa Lepule. Palesa, if you're still here, can you indicate, and then otherwise I'll put the question.
Yeah, I'm still here.
Okay, go for it.
My question was, do you think the current crisis will push for a business and human rights treaty, or is a treaty too far down the line because the treaty process does take a long time? Or do we need something else? Do we need to be pushing for something else instead of a treaty at the moment?
Genny, can you unmute, please?
Thank you. So the next questioner is Mohammed Mustafa Haji, if you're still here. Okay, it looks, unfortunately, Mohammed didn't leave a question, but just indicated he wanted to ask a question. So I don't know what that question was, but the next one is Noverti Diografia. Actually, we can't hear you. Okay, Noverti. Noverti wanted to ask a question about what are the ways in which we can rectify human rights violations in the times of COVID? Does that change the options that would be available in normal times? And are there other ways in which human rights can be vindicated now? I think the last person for this round is Sharon Hofisi. Sharon, are you there? Okay, so Sharon's questions were went to the nature of force majeure and whether how COVID, which is COVID, can COVID be considered as a force majeure episode, and if so, what does that tell us about human rights and business in this environment? I think let's take a round of answers to those questions from the 4 speakers, and then we'll have a second round of questions asked after that. So
Genny, please, your microphone.
So Benjamin, sorry,
Yes.
Benjamin, can you?
Yes. Yes, I think the first question is actually addressed to me. So I will take care of this one and let my colleagues respond to the others. So the question is about the treaty, how the whole situation actually can impact on the treaty process, and if this can be a kind of catalyst also to the adoption of the treaty. I think this is, it's my hope that the current situation can be able to show everyone and all the stakeholders how important it is actually to have a clear legal regime on which we can actually rely and ask for accountability when it comes to businesses and the human rights and the activities that impact human rights. So the treaty process is ongoing, as you might know. The process has been officially launched in 2014, and the intergovernmental working group is actually working on the subject. There are so far some kind of evolutions, but also some some point of contention, if I might say. So we don't know exactly. I don't know if I can predict the outcome or the outcome of the process, but for sure, as much as there is a kind of hope and motivation, especially from civil society and also from some African countries, we can also see kind of hesitation and reluctance from actually some Western states and also very conservative corporation lobbies. So this is actually, these kind of tensions are not just, we see that in other international lawmaking process. My hope is that the situation actually can convince everyone that we need a clear legal framework, and which goes beyond what the UN guideline principles have actually provided for us. And for that, I totally agree with Luis when it comes to how we interpret the due diligence principle, but more specifically, how we deal with the nature of human rights obligations. I think clearly we should go beyond the do no harm approach and embrace a more positive obligation approach, actually. So that's what I can say. I cannot predict the outcome of the treaty process, but I hope that would be, yes, COVID-19 will help as a catalyst.
Great, Benjamin. Over to Jonathan.
Thank you, Danny. I think I will pick the question regarding the force majeure, because it's also, as I said in my presentation, among the state defenses under international customary law. However, I think less than 1 month ago, the state of Bolivia invoked this agreement because given the current situation, the state wasn't able to fill a statement of defense in the deadline. So this state asked for a kind of extension based on this issue. However, a general comment on, finally the tribunal rejected this defense because in order to invoke this, you have first to have a violation of an international obligation. because this is a justification. You can justify only a violation. So, but generally speaking, those defenses under international customary law are, I mean, rarely successful. I mean, and it's, even if in the current situation, some aspect, because in order to invoke the force majeure, the event might be external to the state, unforeseen event, and so I think that it's not a, at the end of the day, it's not a very strong argument, because it's difficult to what even the World Health Organization said is that this situation is a global pandemic. But if we want to have the proper description or qualification of this, maybe we need to wait a bit for some claims where probably this issue will be addressed by some investment tribunals, and we'll see probably what can be the best defense to invoke, because we have the state of necessity, the force majeure, or the distress. Those three are those we can invoke in the current situation. So I think it's, yes, in the same vein like the state of necessity, it is difficult to invoke this defense in the context of investment arbitration.
Great, Louise.
Sure. So I'll just comment two quick things. One, I think just following up on Jonathan's and the question on force majeure, I think there are two elements to think about. There's an element or a dimension which Jonathan was talking about, which is the dimension within investment law. And I mean, I think there can be different interpretations. I mean, one of the things we've had in investment law is that actually you have, and this is clear on Argentinian cases and Spanish cases, in which the exact same situation with the exact same measures by the government were interpreted by different tribunals completely different, right? So some considering that there were legitimate measures that they did not breach, for example, the fair and equitable treatment standard, and other tribunals saying that actually the exact same measures did breach. So how we interpret, or how we're going to see an interpretation of that, I think it's very difficult to tell. There is a case to say that actually clearly the crisis requires a certain amount of measures, and those measures are legitimate. But you could see discussions if you were to interpret, for example, the decision that the South African government took in terms of alcohol and the sale of tobacco, if there are sufficiently legitimate or reasonable in terms of indirect expropriation claims and so on. So we don't know what that's going to imply. A second dimension, which I think is really important to talk about, is in the contractual dimension of the force majeure. So what we're seeing, for example, in the US right now is that certain medical insurances are not providing any type of support for those who are actually currently suffering from COVID-19, because it says that in situations of force majeure, or even worse, that they do not cover pandemic situations. So we see the use of force majeure as a way by certain companies, and insurance company particularly, as a way of getting out of the scope of responsibility during the crisis. And that I think is particularly dramatic for the enjoyment of certain rights, particularly the right to health. I think all of this, to one of the questions that was made that hasn't been kind of answered, is the challenges for human rights in general. And I think the crisis is calling us to think particularly how the enjoyment of certain rights is understood. And we've been looking at business and human rights, but of other rights. I mean, if you just think about the right to the highest attainable standard of health, what you're seeing is many countries operating on a basis in which they don't fully consider what the right to health implies from a legal human rights perspective. So I don't know if it's, I don't know if what we're looking at, part of the challenge is to certain mainstream, grounded, legally binding human rights is what we need is to insist and demand in the clear application of those human rights standards. I think there are certain areas of human rights which clearly what we're looking at is not a need to reconceptualize them, but to see that actually they need to be thoroughly implemented as the way they demanded, and the way that its competent interpretive authorities like the UN committees and other regional mechanisms has already called for. So I think that's what we need to focus right now, in the way that certain public health measures, for example, housing measures, labor rights issues are being implemented, and how we go forward in the future.
Great, thanks, Louise. Genny, are you there?
Yes, I'm right here. I think basically most of the questions have been answered, but I think I'm going to go back to the first question that dealt with the treaty. And I think it's an interesting question, whether this pandemic is going to, I don't know, be a catalyst to us having a business human rights treaty. I'm not too sure if that's a question we should be focusing on. Of course, we need a treaty, but I think we should focus on what form it should take. Right now, the draft treaty is very state-centric, which is reflects the current international system. Most of human rights violations take place in developing countries, like Africa. So my personal research in my PhD, I call for taking inspiration from the African regional human rights system. For instance, when you look at, I just wrote down a list of things that have changed in the human rights system, well, the African human rights system. For instance, if you look at the Maputo Protocol, it directly speaks to corporate entities as opposed to any other human rights instruments that only focuses on the state. The Malabo Protocol calls for corporate criminal accountability, which is very much direct criminal liability of corporations as opposed to going through the state. I think with what this pandemic has revealed, that yes, we do need a treaty, which every situation has revealed that since forever, basically. But I think it also should reopen this conversation on what this treaty should look like. And I find it very interesting that when we talk about a treaty, we talk about business human rights, we don't talk about everything else that relates to it. For instance, if there is a treaty and corporations are held accountable to whatever standard, there are always ways to break and make those walls, these legal walls, crumble, for lack of a better term. If we look at it, international relations, for instance, if a particular country needs foreign loans or foreign aid, for instance, there are conditions that are attached to those loans. And if an international financial institution claims that one of the conditions is that you have to relax your legal system, this particular country will do exactly that because it is dependent on aid or even foreign direct investment. So I think we have to also reimagine, as this webinar calls for, what this treaty should look like. And I think we have to go beyond just looking at the legal aspect, because international relations bleeds into international law. If there is a breach in international relations, there's adverse human rights implications, which is very much an international law arena. So I think that, this conversation is endless, of course, and it'll be interesting what comes out of it. Thank you.
Thanks, Genny. As you can see, this is a very rich discussion, which has left us with a difficult situation. We've got 15 minutes. I have a list of 7 people who want to ask questions, and I want to get as many people involved as possible. So what I'm going to suggest is, if each person speaks for a minute, and then we give each of the speakers a minute to do a concluding remark. So they won't answer all of the questions, but they'll be able to respond to at least the ones that they feel most qualified and comfortable responding to, and then we'll finish on time. So it's Charles O'Geary is first. Charles, are you there?
Thank so much. Propose.
Charles, you keep cutting out. We're not hearing Try again. Charles, what I'd say is if you send your question on the chat function, I'll mention it, and then we'll go on to the next speaker in the meanwhile, because we can't hear you. So the next speaker is Richard Obidi. Richard, are you there?
Sir. Hello?
Yes.
Yes, my name is Richard Obedi from Uganda. I'm calling in relation to the presentation made by Dr. Benjamin. And he alluded to what we call the UN guiding principles on business and human rights that was adopted in 2011. And my disappointment with the UN is why can't they change the way they do their things? Because if you look at the latest adoption of some of these non-legally binding positions or agreements, look at the Global Compact on Migration that was adopted in Morocco. And I participated in some of the regional consultation, especially at the continental level. So why can't we change the way we do things as UN and any other stakeholder? Because some of these non-legally binding principles will actually make us not realize the accountability gaps that he alluded in this presentation. Thank you so much, sir.
Thank you, Richard. Next one is Oliver Chilefi. Oliver, are you there?
Yes, I am. Good morning or good afternoon.
Yeah, mispronounced your name. I apologize.
No problem. Thank you so much, Professor, for the presentation and all the presenters on the panel. My comment to be very quick is in line with what Genny had earlier alluded to and also the concerns that she raised. I think over time, when it comes to pandemics, especially zoonotic ones, the world has always been found or caught napping, that they are not prepared for it. And then a lot of issues raises up. However, when it comes to business and human rights during such times as the COVID-19, whilst we've talked so much about corporate companies, we've not discussed issues to do with the state owned businesses, or let me say businesses owned by the communities on the grassroots there. You discover, like in my country, Zambia, there are a number of issues that we need to address both through public health and also through economic livelihoods. Individuals or people are largely dependent on, let me say, hand-to-mouth situation. And then times like these ones, you discover that with austerity measures that are brought in order to keep the infection, it affects these families. And hence their businesses are quite, let me say, disturbed, and hence it causes a lot of challenges in the homes. Hence, when we are discussing issues to do with treaties or which will address human rights issues, we need also to start thinking of how we need to domesticate them so that states and also corporate companies adheres and follows them. However, would have a lot of, if not, would have a lot of documents on our tables that will not even address the critical issues that communities and individuals continues to face. Thank you.
Thank you. Next one is from Landelani. Landelani, are you there?
Hello?
Yes.
Yes, my question is mainly based on Benjamin's presentation using the due diligence principles. And what I wanted to find out is using the investment laws that at the moment require most businesses that are setting up their investments in different African countries to have environmental impact assessments. Now, what I'm wondering is, isn't it time, bearing in mind the lessons that we have learned from the COVID-19 pandemic, that states are called upon to make a requirement in their investment laws for a human rights impact assessment, which may be wider and maybe absorb some of the concerns. For example, it can have a component on the environmental impact, it has a component on labor, so that the business and environmental laws can be used sort of as a starting point for the regulations of business, using the impact assessment and ongoing assessment further. Thank you.
Thank you. Next one is Jayesh Raj Purohit. Jayesh, I can see you there. If you unmute yourself, you've got the floor for a minute.
When the business established and human rights with both of you, my question is, the right to food, right to health, and right to education is not disturbed when we going to the business establishment. So many people survive this COVID-19 epidemic lockdown period. So the all rights, human rights can be saved of all people. These survive in the COVID-19 lockdown period. So,
okay, thank you. Next one is Galaxy A20. I'm sorry, I don't have a name other than that for the speaker. Galaxy, are you there? Okay, we seem to have lost Galaxy. Last question is from Fiona. And Fiona, I can see you're on an iPhone.
Hello, hi. My question follows what Genny was talking about. Given that IFIs have invested a lot of money to respond to COVID through public and private, supporting private and public actors, yet some of these IFIs have gone ahead to advise African governments to privatize health service providers without thinking about human rights, implication of that on human rights. And you find that IFIs don't usually like talking about business and human rights in the projects that they finance. How then can we encourage IFIs to start taking this into consideration, moving away from the minimal base of having safeguards within their projects, but starting to talk about business and human rights in projects that they fund? Thank you.
Thank you. These are all excellent questions that would deserve much more of an answer than we can possibly give them credit for in the time available. But I'm going to ask each of the speakers to take whichever questions they would like within the within those that are done. And let's do it in reverse order this time. Let's start with Genny and we'll work our way backwards. And use this time to answer a question and to make your concluding comments. And you have about a minute to do it. So Genny. Genny, you need to unmute yourself.
I am trying to, yes, there you go. Oh yes, hi. Fiona's question, I think that's a very interesting question. I would love to have an answer to that myself. I find that a lot of development projects, they focus on environmental social impact assessments, which is, I suppose it has a certain element of human rights or business and human rights, but it also allows the company who's conducting, or even the state conducting the impact assessment, to pick and choose which human rights they would like to focus on. And the fact that it has been named impact, social impact, it means that it's not really human rights, it's human rights like. So I think it's very important for us to move towards a human rights impact assessment, because the point of the matter is that you have to name the problem. And the problem is that human rights are being adversely impacted and not social society or social elements of society. Yes, You asked IFI investors to support public-private actors and advise African countries to privatize. Of course, that's one of the conditions, as I spoke earlier, that whether it be through foreign aid or development project, those are one of the conditions that may be stipulated. And unfortunately, that is the making the right to health a commodity. How do we move towards make it into our human rights again? To be quite honest with you, I'm not sure. I think these discussions help us come up with solutions. Of course, CSOs and human rights defenders, and as well human rights scholars play a very vital role in putting these issues on the front line. Yes. So to be quite honest with you, Fiona, I am unsure of that. I think this is a very pertinent question, and this is something that I think the reason why South Africa as well as Ecuador have endorsed the Business Human Rights Treaty, because there is a clear consensus among African countries and developing countries as a whole that something has to be done that is different from the status quo.
Great, thank you. Louise.
Okay, so there's a lot to say in a very short time, and I'll try to be as quickly as possible. So human rights impact assessment, there are interesting things that you could read about in general for everyone, and then invite everyone to continue to read and research on this, even if you don't do anything related to development law or international economic law or business and human rights, because I think it's really important for everyone who does human rights job and work to know about these issues. And so there is impact assessment done, for example, by financial institutions. There are the Equator Principles, and there are a lot of issues related to some of the practices that has actually involved. Some positive elements, a lot of negative elements. Sometimes, and I think it's really important to understand why sometimes human rights impact assessment is not the solution or the whole solution, is because there are a lot of very unpredictable things that happen. So a lot of people have argued for impact assessment on investment agreements, for example, but the level of interpretation of what can actually happen in the practice is difficult to deal when you've already put millions and millions of dollars in a project, and then you suddenly have to cancel the project and go back to zero. In terms of IFIs, I think we are going to have a big backlash, and I think it's something we really have to look into the future, because we're gonna require a lot of money from financial institutions to rebuild part of our economic order in general in each country, and we would see probably a lot of conditionings on that. I mean, you see the Bretton Woods institutions saying that they don't incentivize that much level of privatization anymore. In reality, we know that that's not 100% true. So we might see a lot of human rights standards that have been, really kind of put up, being watered down again. How can we make them talk about business and human rights? The only kind of three things that I can think about is through research, activism, and leadership. If we can, from different fronts, continue to press some of these financial institutions, some have done very, very positively in the past with great research and leadership from across the globe, then we might be able to have some impact, even if it's limited.
Great, thanks, Louise. Jonathan.
Okay, thank you, Danny. I think also I will share some of my views on the issue of the human rights impact assessment in the context of investment, saying that at the moment, even if many are advocating in favor of a better inclusion of human rights issues in the context of investment law, we can still see a kind of reluctance, and even the current reform process that are taking place both at the level of UNCITRAL or ICCID. We can see that some countries, like even the South Africa government, in the proposal, they're advocating in favor of a better inclusion of those issues. But in terms of its feasibility, because what does this means concretely, the human rights assessment, because those rights are so broad. Maybe what can be interesting is to provide those who are affected by investment or whose human rights are affected by those investments to have a kind of locus standi. This needs the right to access to the tribunal in order to also participate. This can be maybe a good compromise because, and this is also in line with some recent development because we, at the end of the last year, a new set of rules has been released, had rules on business and human rights arbitration that provide for kind of local standard for people affected by investment. I think this can be maybe at the moment the more practical approach, even if I totally agree that the human rights assessment maybe can be the ideal. This is probably at the end of the process. So this is concretely what I can say on this issue.
Thanks, Jonathan. Benjamin. Benjamin, I think you need to unmute yourself.
Yeah, I'm sorry. Thank you very much, Danny. I think two questions were addressed, directed to me. I would like quickly to answer to the first one, because the second one, I think it's around the human rights impact or environmental impact assessment. And my colleagues have been talking about this a lot, quite a lot. So the first question is on the why the guiding principles are not binding and why UN are adopting instruments that are not actually binding. So this is a very interesting question, and I would like quickly to say that the state of the business and human rights agenda is exactly a reflection on a number of questions that are actually not specific to the business and human rights issue. Actually, it's law-making process at the international level are never very easy, and you have a lot of contradictions and tensions that can be that can make the process in a way that you would, in some case, end up with a very good result, providing that and binding instrument is a good result. Or you might also end up with some kind of soft law, which is not per se very bad. But I can say that in the business and human rights field, there are many contradictions. And as Genny has mentioned, you have on the one hand, developing countries as a whole, and you have some civil society organizations pushing for an agenda that can strengthen as much as possible the regime. While on the other hand, you can see the influence of Western states that host the most important companies, multinational companies, for example, and these companies as well that are also pushing for their interest, which is completely understandable. So the process at the UN level cannot but just reflect these dynamics. And this is not something specific to business and human rights. My hope is that in this situation with the COVID-19, we can find a kind of new dynamism in the field, and we can have more argument. The stakeholders can have more arguments to push the agenda and to move forward with a more clear, a clearer regime and more binding obligations on companies. That would be my last words. Thank you very much.
Thank you, Benjamin. Before closing and thanking everyone, I just want to respond to Felipe Nyanga, who raised the very important issue that this was only presentations done in English. And to say to you, Philippe, en principe, tu as raison. Nous avons besoin pour la traduction en français, mais aussi en le portugais et la langue arabe. Et c'est trop difficile. Et je suis désolé pour l'absence de la traduction. And with that, let me firstly thank all of you for participating and for your interesting questions. And I hope this can be not the end of a discussion, but a step in a discussion and a debate and thinking about how business and human rights can be advanced in general and in the African context specifically. And then I want to thank the speakers, all four speakers. So Genny, Louise, Jonathan, and Benjamin, both for taking the initiative to organize this event and for their excellent presentations today. I thank you also for your patience. We went a little bit over time and with a few technological hitches, but overall, I think it was a wonderful presentation. So thank you, everyone, and have a good day.
Thank you, Danny. Thank you, everyone.
Thank you.
Thank you. Bye.
The